Chapter 9. Qualifying Bonds for Insurance Companies. Sec. 146. Scope. In a number of the states, it is necessary for certain classes of insurance companies, in order to get permission to transact their business in those states, to give bond with surety for the payments of the losses under their policies. The laws in the different states relating to this subject are not uniform, although all of the bonds will fall within one of the three following classes. 1. Those covering all policies issued during a period of 1 year, a new bond being required each year. 2. Those covering all losses that accrue during the year, a new bond being likewise required each year. And 3. Those covering all policies which may be issued and all losses that may accrue, without any limitation as to time. Sec. 147. Liability. When it accrues. It is of course apparent that an insurance company can, if it sees fit, dispute any claim that may be presented, without regard to its merits, and force the claimant to sue and get judgment, and the surety cannot be required to pay a claim that is disputed by the principal. And, inasmuch as an insurance company must pay the judgments against it or go into the hands of a receiver, it is clear that the surety cannot be required to pay anything, so long as the principal is solvent. The insolvency of the principal is therefore a condition precedent to any liability under the bond. Sec. 148. Liability. Extent of. In general, in event an insurance company does become insolvent, the liability of the surety, under any of the three forms of bonds, would be twofold. In the first place, the surety would have to take care of all losses, within the scope of the bond, that had not been adjusted and settled at the time of the appointment of the receiver. In the second place, the surety would have to take care of all future losses on policies then in force and covered by its bond, but this liability could be practically satisfied by reinsuring the risks with some other responsible company. The measure of liability for the outstanding insurance is therefore the cost of reinsuring it. The cost of reinsurance will depend somewhat upon the kind of insurance. In order to reinsure a life policy, where the loss is bound to occur, and the premium is paid to take care of the loss, it would be necessary to pay the reinsuring company an amount equal to the total of all the premiums that have been paid, plus interest at the rate usually earned by insurance companies. In the case of a fire or other similar policy, where the premium is paid for taking the risk of a contingency which may or may not occur, reinsurance could ordinarily be effected by paying the unearned portion of the premium, that is, the premium for such part of the time covered by the policy as had not expired. It is however not to be assumed that the amount necessary to take care of the pending claims and to reinsure the outstanding policies, will be a total loss to the surety. Insurance companies are required by law to carry a reserve for both of these purposes, and this reserve, together with the capital of the company, ought to take care of this liability. Although some insurance companies are lax in the matter of putting up reserves, it is fair to assume, in the absence of evidence of a contrary tendency on the part of the management, that the vigilance of the insurance commissioners in the several states will cause the companies to maintain approximately the reserves required by law. If a company does maintain its reserves, they, together with the capital of the company, would ordinarily be sufficient to take care of its liabilities, and the principal danger of loss to the surety would be the failure of the company as a result of some great catastrophe, such as a great conflagration, plague or epidemic, involving extraordinary losses. If such a catastrophe should occur outside of the state in which the bond was filed, the principal loss, if any, under the bond would be the amount necessary to complete the reinsurance of the policies then in force in the state. If on the other hand, the catastrophe should occur in the particular state, there would no doubt be a large number of losses to be adjusted, in addition to the reinsuring of the outstanding policies, and the full penalty of the bond would probably be consumed. In the last analysis therefore, the contingency to be especially guarded against, is the issuance of a bond for a company that is not particularly strong and whose business in the particular state is so large that an unusual disaster in that state would probably bankrupt the company. In the case of life companies, the danger is probably negligible, as the possibility of a serious epidemic in any of the states in question is very remote, but it is well to avoid fire companies which have a large volume of business concentrated in a single city in the state, and liability companies which have in the state large concentrated risks so that one or two accidents might bring disaster. This phase of the matter must of course be considered in connection with the strength of the company, its total business and the form of bond required. Sec. 149. Liability, as affected by the time covered by the bond. Other things being equal, the desirability of any particular risk will depend upon the strength of the principal. But, inasmuch as the financial condition of an insurance company at any particular time is not necessarily a true index of what it will be in the years to come, it is apparent that a bond which will carry liability far into the future is not ordinarily a desirable risk, no matter what may be the present condition of the principal. A bond which covers all losses that accrue in the future, without any limitation as to time, guarantees the solvency of the principal for all time, and is therefore necessarily an undesirable risk for a surety. Being an obligation in favor of the people of the state, and no method of release being provided by law, the surety would have to continue on the bond, even though disaster might be imminent. Such an indefinite guarantee with no provision for release, is not a legitimate surety risk and should be put on the prohibited list. A bond which guarantees the payment of all losses on policies issued during the period superscripto F1 year may likewise carry the liability far into the future. In life insurance, it often happens that liability on a policy does not accrue for 50 years or more after its issuance, and a surety company cannot afford to guarantee the solvency of an insurance company at the end of 50 years, or 25 years, or even 10 years. Such risks ought likewise to go on the prohibited list. In the case of fire or casualty insurance companies, the policies are most often written to cover a period of only 1 year, although in some cases they do cover 3 or 5 years. While it is necessary to be cautious in guaranteeing the solvency of a company for as much as 5 years, yet the proposition is not necessarily impossible, and the bond may perhaps be executed for a few of the high-grade companies, where the bond guarantees the payment of all losses that accrue during the period of a year. Liability ordinarily terminates at the end of that time, and the matter of guaranteeing the solvency of a corporation for as much as a year is of course not an extraordinary surety proposition. But under the statutes of some states, the liability on one annual bond does not terminate until another is filed, so that if a company should become insolvent during the year, or fail, at the end of the year, to give a new bond, the surety would have to stand all future losses, or reinsure all outstanding policies. Hence the importance, even with this form of bond, of avoiding a company whose premium income in the state is particularly large or out of proportion to its total business and its financial strength. Sec. 150. Summary. The main features of this chapter are, 1. That the insolvency of the principal is a condition precedent to any liability. 2. That the maximum liability is the amount necessary to take care of the pending claims, and to reinsure the outstanding policies, and that, except in cases of extraordinary catastrophes, the assets of the company are likely to be sufficient for those purposes. 3. That the real hazard is in proportion to the probability that a catastrophe in that state would affect the solvency of the company, and, in event of insolvency, the amount of probable loss is in proportion to the premium income in the state. 4. That only those bonds, which guarantee the payment of losses that accrue during the year covered by the bond, are ordinarily acceptable, although it may be reasonable, for selected companies other than life, to execute a bond covering all policies issued during the year covered by the bond.